Okay, y'all, we're gonna get on with the last section. And we're gonna be talking about mediation. We're also gonna have a mediation exercise at the end, which I think will be fun and valuable. But we briefly also wanna touch upon subsidized tenancies, which is something that we're actually gonna see a lot of. It's a pretty common situation for the clients that come up to us at the clinic. So, let's see. Subsidized tenancies are tenancies where a tenant is renting out a place and part of the rent is paid for by either the state or federal government. So there are two types of subsidies, two major classes of subsidies that we'll see. Tenant-based subsidy and project-based subsidy, okay? A tenant-based subsidy is one in which the tenant has the subsidy and they get to use that in an apartment, and if they want to move, they can move to another apartment and they can use that subsidy at the next apartment. It's called a mobile or portable subsidy. It's also known as a voucher. Section 8 is something that you might have heard of. Section 8 is the most common one that we come across, the most common one nationally anyway. But there are also a couple other subsidy programs that you might hear of. They're far less common. But you know, MRVP, VASH, AHVP, those are also subsidy programs. But again, Section 8 is definitely the most common one. Project-based subsidies, those are subsidies that stay attached to a particular unit. Okay, so whoever lives in that unit gets the benefit of the subsidy and the reduced rent. Once that person moves out, wherever they go, you know, they're gonna have to pay rent at that place. But the person that moves in next to that unit that has a subsidy attached will get the benefit of that subsidy. So that particular unit is always going to be subsidized. Yes?
Do they have to qualify income-wise?
Yeah, so subsidies, so to get a subsidy, you're gonna have to qualify. And the different programs have different requirements, but yeah, it's gonna be income-based. Okay. Yes? Sure, so the abbreviation, so MRVP is Massachusetts Residential Voucher Program. VASH is the veterans one that I don't know, sorry, and HVP is Alternative Housing Voucher Program. But again, those are, it's not that they don't exist, they're just way less common than Section 8. Generally to know about subsidized tenancies is that tenants have more protections but also more obligations when they're in a subsidy program. And again, the basics to know is that if there's a subsidy, there's always going to be a lease. Tenants are always going to have to recertify their income and household composition, at least annually. And if any of that changes between the annual recertifications, they're going to have to do what's called an interim recertification. Let's see. Okay, so at the clinic, common allegations for evictions and subsidized tenancies are failure to recertify. Again, that's really, really important. That the tenants recertify annually and also do the interim recertifications. And tenants often either forget to do that or you know, they give incorrect information, and so it's a very common allegation that we see at the clinic that they did not do this correctly. Unauthorized occupants, right, subsidized tenancies, there's always going to be a certain number of people are allowed to live in the unit, and when the client, you know, lets a brother, a sister, a cousin, or someone else stay, the landlord often brings an eviction for unauthorized occupants, failure to pay rent, and criminal activity. All of these are the most common allegations we'll see for evictions when there's a subsidized tenancy. There are lots of rules attached to the subsidized tenancies. They can be pretty complicated. To see what rules apply to a particular tenancy, the first place you're gonna look is the lease. Remember, there's always a lease, so take a look at the lease first. The next step up is gonna be an agency administrative plan, state and federal regulations, and then state and federal statutes. One thing to know about subsidized tenancies, though, is tenants will often ask, you know, does this mean I'm going to lose my voucher if I get evicted today, or what happens today? And the answer is, you know, not necessarily, but maybe. Because summary process is going to be about a possession for the unit, right? And so that's when the landlord is trying to evict a tenant. The voucher program that they're part of is administered by another agency, and the reasons why the landlord wants to evict could also be program violations. And so the termination for the subsidy is going to happen at the agency. They're going to make the decisions there, and the first appeal is going to be there too. So it's going to be up to the agency to bring that termination procedure, and it happens at the agency first. So the things that happen at housing court are probably going to relate to the subsidy termination, but it's not guaranteed that there's going to be a subsidy termination. Yes?
If the subsidy is attached to the unit and they're evicted, won't they lose it anyways?
Right, so this is for portable vouchers, yeah. So yes, if they have to, if the subsidy is attached to the unit and they're evicted, then they no longer get the benefit of that subsidy because it stays with the unit. Okay, so now we're going to talk about mediation. And again, just to situate you like I talked about before with the clinic, I'm going to situate you a little bit about how mediation works at the housing court. It takes place on the 3rd floor. We're up on the 5th floor. And it takes place in rooms attached to the housing court clerk's office. There are 4 mediation rooms, and they're behind a locked door, separating them from the waiting room. If the parties agree to mediation, the case file is sent from the clerk's office, the session clerk's office up in courtroom 10 or 12, down to the housing court clerk's office where the mediators are, and the parties will wait there until a mediator is freed up and calls them. And once they're called, they'll come into a mediation room. There will be a table. Parties and attorneys will sit down with the mediator, and if the mediator will describe what the mediation process is, that if they don't arrive at an agreement, they can always go back to court. And if all the parties agree, then they'll go ahead and fill this out right here, which is an agreement to mediate, and they'll proceed with mediation. Let's see. And again, if mediation falls through, or if you're representing a tenant down in mediation and they don't like the terms, it's fine, because they will always go in front of the judge at the end. You don't have to come to a settlement if the terms are unfavorable. What else? Okay, a couple notes. If you have the benefit of the mediator, go ahead and use the mediator, right? The mediator is your friend. They can calm the parties down. Oftentimes, when both parties are arguing about what terms should go into the agreement or what the other person has done wrong, the mediator can step in and explain those terms in a way that is much better received than if it came from an attorney or the other party, right? You can also use the mediator for things like asking for privacy, so you can speak to your client, and the mediator will take the other parties outside. And the mediators have done this a lot. They're very professional at the housing court. They've heard lots of different stories. They've done a million cases. They've helped settle a million claims. So they're a great resource and a great tool that you can use. That said, the waiting time for a mediator can be pretty long, and while you're waiting, it's absolutely fine if you guys are confident that you arrive at a settlement without using the mediator. There's plenty of time to do that, to talk to the other party if they're unrepresented, or the other party's attorney if they are. So it's totally possible to negotiate a settlement outside of formal mediation. One thing to know about, though, is because we help low-income clients, the settlement terms that are written into an agreement or an agreement for judgment, Dick will talk about those in just one sec, we often want to put in language that's going to preserve their eligibility if they're currently in a subsidy program, right? Or if they're looking to apply to a subsidy program later, or apply to public housing, or try to get emergency shelter benefits. There is some sample language here, depending on the case and the situation, that tries to protect their eligibility. So generally, if it's non-payment, or there's some sort of maybe illegal activity that occurred, generally what you're trying to do is say that the tenant wasn't responsible for it somehow. It was a medical hardship, or this was not an actual guest of the tenant that caused these kinds of things, or just basic language that said, whatever was in the notice to quit or the summary process has not been adjudicated. This is a settlement agreement. So be aware of those and take a look at the sample protective language that's included in the handouts.
So as we said before, most cases end in agreements, and one of the things we do a lot of at the housing court is negotiating agreements. And most agreements in the housing court are in the form of an agreement for judgment. That is, the agreement says judgment enters, typically for the landlord, and then it has a bunch of other terms that could include, for example, time for the tenant to move out, or a probationary period after which the tenancy gets reinstated, and it can also include other terms like waiver of back rent, repair of bad conditions, etc. There's a standard housing court form agreement for judgment, which Milton will bring up. And so often the agreements are done on these forms, but frequently other people will have other forms. A lot of the big landlords and their lawyers have their own standard proprietary agreements for judgments, or you could, like any other agreement, it could be negotiated between the parties. You can see that this one provides things like when the tenant will vacate, or if the conditions are met, the case will be dismissed, when execution will issue, the kinds of terms that we've talked about. Mechanically, what's important about these is that the judgment enters at the time of the agreement, and if the landlord claims that the tenant has violated the agreement, typically the landlord can move for the immediate issuance of the execution. And at that point, the only question is going to be whether the tenant complied with the terms of the agreement. The underlying merits of the case all go away, and it becomes essentially a contract claim where the contract terms are defined by the agreement, and if the tenant is in violation of the agreement, then the execution can be issued. Sometimes there are other forms of agreements that get used, and so we've been encouraging people where they can to use an agreement where judgment does not enter until and unless it's actually necessary. So the agreement could have all the same kinds of terms, but instead of saying judgment enters now, and if there's a violation by the tenant, execution will issue, instead, nothing enters now, and if there's a violation, at that point, judgment enters, and execution can issue. There is not a standard form for the court, so we've shown you that the court just has a blank agreement form in which the terms can be written, and you could write in something like the terms that I described to you. It will be seen as a slightly odd creature in the housing court, which is used to agreements for judgment, but we are seeing some cases where there are agreements like this, and a major benefit of it is that no judgment ever enters against the tenant until and unless it is necessary. And if it's not necessary, then the case just eventually gets dismissed without any judgment being entered against the tenant. Go ahead, question?
So basically, would you recommend in cases where the tenant is like a subsidized tenant, would you recommend that approach?
I do. I do, and it's especially true because increasingly landlords are using mass courts, which is the online dockets, to look people up and see what they're like. And if you've had eviction cases on your record, it may make it harder to find another apartment. So in general, but especially in the case of subsidized tenants, we encourage people to use this form, but you may get pushback from the landlord who says, no, they want an agreement for judgment, or they just want to use the form that they always use, and then you may have to then weigh those considerations against other considerations. If you got a wonderful deal, it might be worth saying, okay, you give me all of the stuff on the substance that I want, I'll give you your form. So like any other terms of agreement, it's a factor that you have to balance against others. So we're going to now break up and actually try doing some mediation. So we're dividing the room with the tenants over here, landlords over here, and table in the back. You guys are landlords. Did I get it backwards? Okay. Let me try this again. So tenants over here, these three tables and the back, and landlords, those three tables and these two in the front. And so hopefully you got the right paperwork for that. And so what we want you to do are a couple of things. One of them is we're going to assign a bunch of people to be either landlords or landlords' lawyers or tenants' lawyers. And so once we do that, we want you to pair up. Lawyers find a client, clients find a lawyer on your side of the room. And then we're going to give you 5 minutes for the lawyer and the client to talk about the case and think about what you want to do in mediation. And then we're going to go into some actual mediations. We have 5 mediators here, so I want mediators to raise your hands. Okay, Everybody see the 5 mediators? And the mediators all have numbers, and I'm just going to tell you where to go. So it's going to be 1 over there, 2 back in the corner, 3 in this corner, 4 in this corner, and 5 in the middle. That's as separated as we can make you. So the mediators, you have your numbers. So 1, 2, 3, 4, 5. And then we want the lawyers and their clients to take 5 minutes to talk about the case, think about what you want to get in mediation, and then, so stay where you are for that, but once we are then going to say, okay, it's now time to go to mediation, and you will have a number, and you will take your number and go to the mediator with that number. You don't have to remember all of that. We'll give you the steps as it go on. But I wanted to give you a picture of where it's going. So for right now, what we're going to do is Milton has little cards. And so Milton is going to hand them out. It's tenants on this side and lawyers on the other side. So Milton's just going to hand out cards to tenants and their lawyers over here, landlords and their lawyers over here, and we're going to give you 15 minutes for lawyers and clients to consult.
Actually, Alec, you want to help me out with this?
Yep. Okay, want to bring people back up. Does anybody have an agreement? Is anybody like within 30 seconds of an agreement? Okay, you 30 seconds over there. Okay, and I don't know over here. Anybody else close to an agreement? Nobody has gotten there yet. One group says they're within 30 seconds. But it can't take much time. Okay, we're getting close to the end of that 30 seconds.
Okay, we're gonna shut this down. So if you arrived in an agreement, great. If you didn't, that's okay too. There's still gonna be stuff to talk about. So
We do have to give a round of applause to the actors. They were great.
yes, well done, all of you, for volunteering, even though we made you do it. Thanks. Okay, so for the mediators, were there any groups that came to an agreement or an agreement for judgment? Anything actually get hammered out? Yeah, group 5. So,
Okay, so we didn't iron out every term, but we did agree to an amount of $1,750 on a payment plan, and the family stays in the house, and the landlord, of course, continues to provide heat that's appropriate. But what we had just started to talk about was whether there would be an execution as part, as sort of a hammer over the client's head in case the tenant's head, in case they weren't able to meet the payment plan. So we hadn't ironed that out, and that's an important issue.
okay. Anyone else come close to an agreement? Any other groups? Yeah.
Okay, cool. We're settling on a number still, so we haven't gotten to your point yet, but we're somewhere between, it sounds like, somewhere around 2,500 is where they're moving towards. I don't know how much more movement there's going to be, but
2,500.
you were at 3,000, so they're at 2,500. So
2,500 going which
somewhere
way?
in there. It's somewhere in there.
Wait, 2,500 going which way?
To the landlord
Okay.
for use.
Okay. Were there any groups that did not see eye to eye, and it looks like it's going to go to trial? These two? Right.
That's where we ended up, but it was, we actually came to a similar, okay. The tenants were willing to pay 1 month of the 4 and the landlord wanted 2. So it was around where these guys came out, but there was no, we didn't get enough, I guess if we had more time, we might have tried to get somewhere in between, but.
I guess I don't see, I guess from the facts, I guess as the landlord facts, like I don't see why any of the tenants, maybe I just didn't see, because I didn't see the tenant's side. If I were a tenant, I would not even mediate on this. Like, I mean, like there are several clear violations. Like I was just like, as the landlord's attorney, I was trying to sit over here and like skate a little bit because I'm like, my landlord has done everything under the sun. I already have 3 months for quiet enjoyment. I have like, I just didn't understand what would incentivize a tenant to come to the table on this.
Okay, let's talk about that in just one sec. Over here, you guys looked like you're about to go to trial too. What were the sticking points here?
Well, I think the sticking points were that the landlord started off with the only thing that they would reduce the rent for was the cost of the space heater. And that did not get things off to a very good start. Yes, and maybe a little bit of electricity, but they were not very generous. So that got the tenant obviously angry.
Okay. Oh, good. Who was the tenant? Oh, were you pissed? Nice. Okay. Okay, so were there any kind of facts that came out here in mediation where one side was really surprised by the position the other side took about something?
I was pretty surprised that the landlords were willing to give us the rent back. But then we also jumped our utility bill to $3,600 period. So
Okay.
I think the landlord had a tough position in this whole case. And I was a little surprised that someone over here just said they were surprised, or I think it was you. Who just said that? Yeah, I thought, yeah, I know, I agree with you, that I think it was a tough position for the tenant to want to sit at the table.
Okay.
Right.
Okay. So I actually wrote this in so there'd be more of a fight between the security deposit and the last month's rent. Was no one surprised that the other side said that's not at all what the payment was for? Because security deposit has triple damages, right?
Yeah, we purposefully avoided that topic. We told, yeah, we just were like, we'll give you proper.
Right, as the landlords. So that's great. As the landlords, that's exactly what you want to do is avoid the security deposit issue. But were there any tenants or tenants' attorneys that wanted to push on that? Okay, and what was the calculation to not pursue that?
Well, we said that if we couldn't settle, we would have claims based on that, and we would make a counterclaim based on loss of enjoyment because of the landlord coming in when we weren't there, and made various other threats. But we didn't really, since we were able to come to an agreement on a number that would preserve the rights of the tenants to stay there where it's convenient for them.
Right.
That was my client's number one objective. So we didn't really hammer on that too much.
Okay. Yeah, so that's a good calculation, right? So speaking with your tenant, you might have what you think is a really good case, and you might think you might get a lot of damages for it, but what was important to your tenant was I want to stay here as long as I can because it's really convenient for me and my partner get to work. So forget about that. Just get us as much time as we can possibly get to stay here. So yeah, okay, that's a good balancing. Is there anything else that surprised anyone or?
Yeah, I think there was a good point made from the opposing side about the emphasis on the access to the property, the lack of access and why that contributed to the delay in potential repairs.
Mm-hmm. Yeah. So the lack of access, right? There's going to be two sides of the story, and there's two sides of the story to everything here, right? And you guys came up with a variety of different solutions, trial maybe, right, and get this worked out in court because you guys can't see eye to eye about certain things. And that's kind of what this was designed for, right? And you can hear what the other groups weighed and what they thought was going on. And none of these things are really clear cut, right? And we kind of wrote it out this way just so that you guys could talk about this. Yes, there might be quiet enjoyment issues, right? Breach of warranty of habitability issues, maybe retaliation issues. Well,
Definitely retaliation, it's just statutorily, right?
so with the retaliation, right, there's going to be the presumption for a defense for possession, right? But there's no presumption for the counterclaim for money.
Oh, right, but I just want to stay in there, so.
Yeah. Right. Okay. Okay. So there's that.
And remember, the presumption is rebuttable. So if the tenant says, there's a presumption of retaliation that you're evicting me because I complained to inspectional services, what's the landlord going to say back to that?
My mom was sick. Okay, well, then I'm just going to present evidence of how you tried to come in my house, all this other stuff, and how to.
You should come next Thursday. This is great.
I'm sorry,
Yes.
how can you make that argument when they're behind on their rent, so.
So
You
you're
don't
saying
have
as the tenants?
Yeah, exactly, the landlord doesn't have to defend against the presumption because.
Well, they do for the defense.
So there's a,
landlord would just argue.
in a non,
Right. So right.
right, in a non-payment case, there's a the presumption is available as to the defense if you meet the other elements of the presumption. It's not available as to a counterclaim. So the tenant can still defend, saying the eviction is retaliatory, and it's presumed to be retaliatory because I went to inspectional services, and then the landlord served me with the summons and complaint. So the tenant, we think, makes out the presumption of retaliation, but the landlord then gets to rebut that presumption of retaliation, and what's the landlord going to say?
Okay, so that practically works out that if you meet the elements of retaliation as a defense in a non-payment case, that would tip toward you get to stay, the eviction is defended, but it doesn't tip the balance as far as getting the damages.
That doesn't tip the balance on the money, because there's no presumption on the money in a non-payment case, and the landlord gets to rebut it, so the landlord is going to say, I didn't do this because they went to inspectional services. I was already planning to evict them because they were already in arrears on rent. And what do you think the judge is going to find as a fact on that? Is the judge going to say, well, that's not good enough to overcome the presumption, or it is good enough? And right, it's pretty easy to imagine either way. So they have the presumption, and that's powerful, but it's not dispositive.
And remember on this idea that the landlord would have done it anyway, right? Because the mom is, was it the mom who's sick or something like that?
Yeah, the mom was.
So, right. So the thing is you know, these tenants had a lease. So even if the mom was sick, they.
Even if the mom was sick, you gotta give me heat. I'm sorry. Maybe
No, I'm saying for the purposes for purpose of the retaliation to defeat the presumption, the landlord would have to show, right, that they would have brought the action in the same way at the same time. The landlord couldn't have done this because the tenants had a lease. Okay.
Wait, for the non-payment? You
No,
couldn't
not
have
for the
brought it?
non-payment. I'm just saying, if they were saying, if what people were saying was like, I would have brought this because my mom needs the place,
Oh,
that's
yeah.
not a reason.
I was going to ask about the defense of withholding rent as a defense to the non-payment. To what extent, so obviously, well, it seems like they weren't entitled to withhold the entire amount of rent. So to what extent will a judge say, well, you withheld too much, so I'm going to give possession to the landlord?
So you can always withhold the entire amount,
Oh,
and then it's going to be figured out later how much you have to pay back. So you don't figure out in the first part, like, I think this is worth half my rent, so I'm going to withhold half my rent. You can withhold the entire amount.
But the timing on that is important, because the landlord has to know about the problem
Before
before
you
the tenant
withhold.
is in arrears.
Yeah.
So if the tenant is in arrears first, then they don't get 8A at all. And so even if the judge were to say, so then they don't get that 7 days to pay out.
What about the fact? Sorry. What about the fact that the February rent hasn't been paid, even though the heat's been fixed, and so the tenants are in this weird position where they're still saying we're not paying without justification. Does that change the presumption, or is that too late in the day to matter?
So landlords are going to be confined in a summary process to the things that they allege on the notice to quit. Okay, so the case about possession is going to be about those amounts. All right, and then they can also say they're still behind for February too, so I want that in the judgment. But that's not going to affect possession, that they're behind for February.
Want to do a time check, because we had told you we would get you out of here by noon, and we're now 5 minutes
Yeah.
over. We can go for a few more minutes if you would like to, but we don't want to ask you to stay longer than you committed to stay. And we also want to give Ryan an opportunity.
So Ryan, who was a mediator here today, is also, he works for CPCS, and he actually has another volunteer opportunity that he wants to speak about, and I wanted you all here too.
So I work for the Public Defender's Office. I used to do some housing work with the LPD, but it's not a separate volunteer opportunity. But I just wanted to talk about the cases that often come in that are associated with criminal cases, where a lot of the clients of the Public Defender's Office, those that do have housing, it's common for them to have subsidized or public housing. And as was mentioned before, there are a lot more obligations on the tenant side in terms of criminal activity is one of them, that it's really easy for them to lose their housing if they're even charged with a crime. So there are cases that I've seen where the criminal charges are dismissed for lack of probable cause, and a housing authority still continues to pursue a termination of the Section 8 voucher or the public housing. So those are situations where you're entitled to an attorney for the criminal case, but you're not entitled to an attorney for the housing portion. And in some cases, losing your housing, especially if it's subsidized or public housing, can be a much more devastating than what a potential criminal consequence would be. So my office, sometimes comes across these issues where our clients tell us that they received a notice to quit or a notice of a termination of a voucher, and we're actually unable to represent them on that housing case. So if there are people like all of you who are interested in that type of case and working with these clients who sometimes they are the person charged with the crime, but these obligations relate to the entire household. So if any member of the household is charged with a crime, then the entire household's voucher can be terminated. It's a big impact on a family. And if we're able to get a volunteer to provide some legal assistance, it can be a huge benefit. So that I just wanted to throw that set of cases out there if any of you are interested. I'm going to be talking to Milton if there are any cases that come across my desk, and then he can pitch that to the volunteers.
So thank you all for coming today. We hope that this was
Thank
helpful
you to the mediators
We want to
for
especially thank the
sponsoring.
mediators. We want to thank Kathy for hosting. We are available to help on backup. We hope that we'll see you at some of the Lawyer of the Day times. We'll hope that we'll see you in some of the homeless clinics. I wanted to ask if our 5 mediators and Mia could stay for about 10 minutes to do debriefing. That would be great.
Okay, thanks all.
Thank you all.